Hidden assets in divorce and For Me Explained. Hello, and welcome to another video. Today I'd like to talk about one of the questions I'm asked most often. Can someone hide assets during divorce proceedings? The simple answer is yes, it can happen. But it's important to remember that not every concern turns out to be evidence that assets have been deliberately concealed. In England and Wales, both parties are under a legal duty to provide full and frank financial disclosure during financial remedy proceedings. The court relies on that information when deciding how assets should be divided fairly. Most people comply with that obligation. However, there are occasions when one spouse believes the financial picture doesn't quite add up. Well, perhaps their husband or wife has always managed their finances. Maybe there's a family business, investments, or property that they know very little about, or perhaps their lifestyle appears inconsistent with the income they've declared. Those concerns don't necessarily mean assets have been hidden, but they may justify further questions. So what do we mean by hidden assets? It's not always a secret Swiss bank account, as television dramas would have us believe. Hidden assets can take many forms. It could be an investment account that hasn't been disclosed, shares in a private company, a property held through a company or another legal arrangement, cryptocurrency holdings, premium bonds, valuable collections, or money transferred to another account shortly before divorce proceedings begin. The key point is that every case is different and context matters. A forensic investigation isn't about making accusations. It's about reviewing the available evidence objectively. That might involve analyzing financial documents, examining company information, reviewing publicly available records, or working alongside forensic accountants where a business is involved. The aim is to identify whether there are genuine inconsistencies that require further explanation, not to assume wrongdoing. It's also important to understand what a forensic investigator cannot do. We cannot hack into email accounts, we cannot access private bank accounts without lawful authority, and we cannot obtain evidence illegally. Professional investigations must always be carried out within the law because evidence obtained improperly may do more harm than good. If you're concerned that financial information may be incomplete during divorce proceedings, the best first step is to discuss your concerns with your solicitor. If they believe further inquiries are appropriate, they may recommend instructing a forensic investigator or forensic accountant to review the available evidence. The purpose is always the same: to establish the facts so that decisions are based on evidence rather than suspicion. I hope you found this short explanation helpful. Now, I'd like to explain something that often causes confusion during divorce proceedings in England and Wales, and that's Form E. If you've recently started financial remedy proceedings, or you've spoken to a solicitor, there's a good chance you've been told you need to complete one. But what exactly is Form E, and why is it so important? In simple terms, Form E is a financial disclosure document. Its purpose is to provide a complete picture of your financial circumstances so that both parties, and ultimately the court if necessary, can make informed decisions about a fair financial settlement. It isn't simply a list of what you own. It's much more detailed than that. Form E asks for information about your income, savings, investments, pensions, property debts, business interests, and regular living expenses. You'll also be asked to provide supporting documents such as bank statements, mortgage information, pension valuations, and evidence of income. The key principle behind Form E is something known as full and frank financial disclosure. That means both parties are expected to disclose all relevant financial information honestly and accurately. The court relies on that information when considering financial arrangements following divorce. One question I'm sometimes asked is, what happens if someone leaves something out? Well, sometimes omissions are entirely innocent. People forget about an old savings account or misunderstand what they're required to disclose. However, if significant financial assets or income are deliberately omitted, that can have serious consequences. The court has wide powers to require further disclosure, and in some cases it may draw adverse conclusions if someone has failed to comply with their duty of disclosure. From a forensic investigation perspective, Form E is often the starting point rather than the end of the process. The information contained within it can be reviewed alongside other financial records and publicly available information to ensure that the overall financial picture appears consistent. For example, if someone declares a relatively modest income and appears to maintain a very high standard of living, that may prompt further questions. Equally, the review may confirm that everything has been disclosed correctly. It's important to remember that asking questions isn't the same as making accusations. The objective is simply to establish the facts. If you're completing Form E, my advice is fairly straightforward. Take your time, be accurate, provide the documents requested, and if you're unsure whether something should be included, ask your solicitor rather than making assumptions. Good financial disclosure helps everyone involved reach a fair outcome and can often reduce the time, cost, and stress of resolving financial matters. So I hope this has helped explain what Form E is and why it's such an important part of divorce proceedings in England and Wales. If you'd like me to cover another topic in this series, please leave a comment below. Thanks for watching, and I'll see you next time.